You see, I've just actually typed this in again now, right? Because obviously I've actually got a complaint, an official proper complaint, right, to the judicial conduct about this, right? You know, because that Aidan Eardley, he is practicing as a judge now, right? But he's also practicing as a barrister and even working for the Attorney General. Now, I thought that was strange, and I found the statute law that says that you can't do that, right? But obviously it's quite an old, ancient law. But I complained and nothing seemed to happen, right? And apparently he's still doing this job, that Aidan Eardley. And I thought, I'll type it in again, right? Because we've got all this fancy AI, right? And it's supposed to search the internet for the information, right? And obviously this AI can be wrong, but I've typed it in again. I've put, right, in the UK, when was it, when could judges practice as barristers while they were still serving as judges, right? In the UK, when could judges practice as barristers while they were still serving, obviously, as judges? And this is what the internet has said without me having to search through hundreds of websites, right? This is what it says. So, I mean, obviously, if Google's wrong, then, you know, there's serious issues with what Google's telling people, right? It says it has never been a standard or accepted practice in the UK for serving salaried judges to also practice as barristers simultaneously, right? Well, that's what Aidan Eardley seems to be doing now. A long-standing convention and specific conditions of service have always prohibited this to ensure judicial independence and avoid conflicts of interest. Well, that's the whole point. Conflicts of interest, right? Because if you're a judge and you're also working for the Attorney General as a solicitor, and there are certain things that this Attorney General would really, really like to prove, right, and he's trying to get his paid solicitor to prove it, then it'd be all right if, as a judge on another day, that he could just make that order put through, right? However, the rules for retired judges returning to practice have been the subject of change and debate in recent years, right? So that's like Brian Leveson. Brian Leveson is a retired judge, and so is Jonathan Swift, I think, or he's working on the Boundary Commission. I don't know if he's retired or not, but they had him up on a case recently when I thought he'd retired. Rules regarding serving judges. For as long as modern judicial appointments have existed, there have been rules and strong conventions against serving judges holding a second role as a practicing lawyer. Statutory prohibition as far back as the County Courts Act 1846 and later the County Courts Act 1959 legislation specified that a serving county court judge could not practice as a barrister or be involved in a solicitor's practice. Well, they've got him in the High Court as a trainee judge, but, I mean, I don't know if he's volunteering for it. Maybe he can do it until he gets paid. Maybe if he's not... But this is the thing. It doesn't matter whether he's getting paid or not. It means justices of the peace at the magistrates court level are voluntary, right? They volunteer in the role. But any High Court judge higher up, right... they're paid. And even if you're being trained, you're getting to judge on cases. Now, even if you weren't getting paid, then you'd still be able to imply a conflict of interest, right, if you had one. Conditions of service. Judges, particularly those in salaried positions at the High Court level or above, accept their appointments on the express understanding that it is for the remainder of their professional life that they will not return to private practice as a barrister or solicitor. Changes for retired judges. The only shift that this area relates to judges who have retired or resigned from their full-time salaried positions. Recent changes. In 2006, the Lord Chancellor announced that judges would be allowed to resign from the bench and return to practice as barristers or solicitors to aid in judicial recruitment. This decision aimed to make judicial roles more attractive to lawyers who might be reluctant to commit a job for life, right? So that was, he's saying 2006. In 2000, that's not that long ago, is it? 2006, the Lord Chancellor announced that judges would be allowed to resign from the bench and return to practice as barristers or solicitors to aid in judicial recruitment. Research in recent years show that many do take on various forms of legal work, such as arbitration or giving legal opinions, and professional bodies like Bar Standards Board can issue them practicing certificates, sometimes with conditions attached. They may not appear before a court they're used to sitting. They may not appear before a court they're used to sitting. Well, Aidan Eardley he's at the High Court, isn't he? But he's also appearing at the High Court. So, in summary, the core principle remains: a judge cannot serve on the bench and simultaneously practice as a barrister. So what I've just searched this now, and this is meant to be AI, and it's meant to find the truth, and it's even quoting some modern stuff in 2006, right? I mean, the whole name Aidan Eardley, right? It's almost like he's specifically been chosen because of his name, like recruited or headhunted by, I don't know, the government, or, it's almost like his name is Aidan, right? So to aid someone is to help them, and den is a den, right? It's almost like the chambers is the den, or the courts, the court chambers or whatever, the den, you go into the lion's den, into the courtroom, right? With the justices. Aidan Eardley, right? Did anyone hear that? I heard something the other day. I heard that, apparently judges can't be practicing barristers, right? Did you hear that? Did anyone hear that around? Anyone heard that? Right? Aidan Eardley KC is also a King's Counsel. Now, this guy is a favourite amongst the High Court, particularly with the Chief Justice, right? He's a favourite of the Chief Justice and all the high, Victoria Sharp, etc., the highest judges of the country, right? And then also he's working for the Attorney General. I mean, surely, if there was ever a principle where it's unfair to have a serving barrister who's hearing cases in the High Court, actually training or learning to be a judge in the High Court at the same time, right? But also working for the Attorney General, working for the government, bringing cases on behalf of the government, trying to prove things and get things through the court on behalf of the government when he's working as a judge. I mean, it couldn't be any worse, to be honest. I mean, Aidan took He is a co-author of Duncan and Neil on defamation and contributor of Average Edian Smith on contempt. Apparently, this is ridiculous. He's an author in contempt, right, of normal courts, but it's the police and CPS and the courts who are in contempt of Parliament, but Parliament aren't actually hearing any cases. It doesn't exist at the moment because Parliament aren't having and don't hold contempt proceedings. So when people are acting illegally against the law of Parliament, there's absolutely no one and nothing to hold them to account because there's actually there's no trials, there's no hearings. It's like the court's closed down. But the offences are being committed against us, right, by the police, CPS and courts. Says Solicitor General. It's almost like they've purposely picked him out because his name, Aidan, right? Because that's what you're not allowed to do. If you're an acting Attorney General, you're not meant to serve as a judge, right, in another job because you're helping out, you're helping the court out, get your ideas or principles through when you're working as a judge, or whatever, or you can even courts are meant to be independent from the legal sector that are bringing cases, right? Wouldn't it be great if all of the practicing barristers could be judges and then make judgments on their own cases or on the pals' cases or the friends' cases for them, right? They're not really meant to cross that boundary. And to me, it seems like it's trying to mash all that up, abolish it, and make this principle where anything goes, throw a caution to the wind, like Tony Blair with his setting the law against the judicial oath, right, of favours for justice, right? And so he invented it. Every single thing that is unfair, that brings bias or is unprincipled, it's almost kind of like, they didn't used to mention... when you go on the radio, you didn't mention Asda or Sainsbury's or whatever because it's giving business to them big companies and giving them an unfair advantage, right? Almost like the election laws have been flaunted, with Nigel Farage and Talking Pints. It's like all our values and principles of fairness, right, and honesty and integrity have kind of just been absolutely thrown to the wind, right? Completely cast aside. And now, since the corporate sector is all competitive and taking over and win, and all our rights have been stripped away, we're actually the fundamental principles of fairness have just been completely, are being in the process of being abolished, and it's just kind of like a masters rule all model now. Like Keir Starmer, what he's doing now in the government, he's just everything that he's doing wrong, illegal, unprincipled. He's just ignoring it. He's like a complete and total fascist, which is the undermining of the opposition, right? Here, look. He sits as a deputy High Court judge and a criminal recorder, but he's at this chambers, at this barristers available, and I know that he's been acting as a barrister because he's acted for the Attorney General, and I've actually complained about him. And the case got investigated and shut down. Now, the evidence that I found, look, this is a little bit of the snippet because I've made a little bit of a pun out of this. This is my pun for this, right? This pun that I made with his little Barrister Chambers profile, but this has got that's the actual statute law, right? It's the actual statute law itself, which it says that, and this is a 5 George 2nd C18, right? Volume 16. So this is old statute law. So this is this is like a long-established and ancient principle in English law, right? Going back decades into our ancestry, right? That no attorney, solicitor, or proctor to be capable of being a justice of the peace during the time as he shall continue in the business, right? Well, the justices of the peace were even the ones who acted voluntarily without being paid, right? And they were lowest. So if you're not allowed to be the lowest, then surely you can't be the highest. But that's the basis for it anyway. So as long as they shall continue in the business, right? So you can't be a practicing attorney, right, while you're a judge. That's the basis of it. So how have they... why is Google coming up with this information when I just typed it in to check, has the law changed? Or at least up to 2006, it's suggesting that it hadn't. So what is actually going on? You'd have thought the Solicitors Regulation Authority would know that. You would have thought that the bar standards would know that. You would have thought that, he's definitely not just practicing as a solicitor. He's acting as I've seen him. He's acting as a barrister because he's acting for the Attorney General as a barrister because he's been appearing in the High Court. And so I really don't know what they're playing at. And why would the internet come out with that information when I just double checked it again? And this is the type of guy who's knocking around at the Royal Courts of Justice. He'll be right in with the hardcore, like the lawyer scene of London, like the complete and total affluent, elite, boutique, whatever, I mean, Alan Robertshaw should be all over this, right? Maybe Alan Robertshaw knows the answer, why I'm wrong. Maybe Alan Robertshaw knows the exact rule of law that, he says I'm completely wrong. But isn't it unusual that when I've just typed it into Google now to ask Google has just agreed with me, right? Google just agreed with me at least up to 2006 or whatever. So, that's not that far back. If it's been an update since then, why hasn't Google registered it, right? And everything that they're saying is that it's not a good idea, and it hasn't been the practice even up until 2006. Why would they change it? They seem to be shedding all their values. Now, if he's deputy or recorder, it might be different, but he's still hearing cases and it's in the High Court. So, surely someone else has got to be interested in this and think that it's not right,